Hello everyone, I'm here to do a quick approach and video for land sale contract of real property for the California bar exam. Usually probably just a paragraph if you're dealing with a land sale contract, but this is also a good lecture for MBE questions also. So my approach here is to state the rule. State the rule, merger doctrine, contract law information, marketable title, equitable conversion, and the remedy for breach. So once again, rule, merger doctrine, contract law, marketable title, equitable conversion, and remedy. And I'll go through each one of these with my slides here. Okay, so my first one, land sales contract. The contract for a conveyance governs a land sale of interest until the close of escrow, then the contract merges with the deed, then becomes the operative document. So I did mention here we're talking about the merger doctrine. That's what that is here. So basically, first of all, the governing contract of the conveyance is the actual, the contract that we're using. Okay. And that's until the close of escrow. Once it closes escrow, then the contract merges with the deed. Now the deed is the operative document. We get a lot of these on MBE. So remember, once the contract merges with the deed, whatever's in the deed is the operative document if it's going to go to court or anything of that sort. So the contract is just good until the close of escrow. Then it merges with the deed, and whatever's stated in the deed is what the court goes by. Okay, so that's the merger doctrine. Merger doctrine, see above. You need to know this for MBEs. Yeah, you do need to know that. Contract law governs the sale of land. Statute of frauds, of course, its requirements are must be in writing, the name of the party, signed by the party to be bound, describes the land, good description, states some consideration. So all of these need to be actually addressed, all these elements addressed for statute of frauds requirement. Now, if you want to get out of the statute of fraud, there's some exceptions here. Part performance, substantial improvements, or partial or full payment. And I memorized that with PIP. So we have P for partial performance, improvements, and partial or full payment, PIP. So that's to get out of the statute of fraud. So if any of these apply, you need to write those up also. Next is equitable conversion. Once the contract is signed, the buyer is deemed the owner of the property. So that's very important here. Once the contract is signed, the buyer is deemed the owner. So now it goes over to the owner. That's equitable conversion. Now, even though the closing has not yet occurred, that doesn't matter. So in your MBEs, they're going to ask you these questions. Now you have to know that as soon as the contract is signed, then the buyer is deemed the owner of the property. Now, they give a lot of MBEs on this damage or property destroyed. Who does the risk of loss pass to? It passes to the buyer. Why? Because once the contract is signed, the buyer is the owner of the property. So damage or property destroyed prior to closing, the risk of loss passes to the buyer, unless there's a statute that states otherwise, which I've never seen, but there might be in your essays. If there's a statute that states otherwise, then you're going to have to go by that statute. That's equitable conversion. Next, you write up the remedy for breach. If there is a breach of land sales contract, remedy for breach is damages or specific performance, and the court prefers specific performance because land is unique. And my mnemonic for that is chocolate cheesecake is my favorite dessert. And this is how I remember how to write up a specific performance rules and elements, or I'm actually the elements of a specific performance remedy. Valid contract, so C for valid contract, C for consideration satisfied, or the consideration satisfied. I'm sorry, that should say considerations. No, contract conditions satisfied. I don't know why I wrote that. That's not right. As soon as I read, I knew it wasn't right. Let me fix that. Conditions satisfied, not considerations. Conditions. So are the conditions satisfied that were imposed on the plaintiff? And then we have inadequate legal remedy, and of course, damages can be inadequate because they are too speculative to calculate. So they can't calculate them, so they can't do like a damage or money certainty on that. It's too speculative, so you have to write that up. And because property is unique, we know that is an inadequate legal remedy there. Mutuality of performance. Both parties to the contract must be eligible to have their performance under the contract ordered by the court. Feasibility. The injunction cannot be too difficult for the court to enforce. And there can be no defenses. So no defenses. So you can't, there cannot be latches, unclean hands. Now, Pammy said foo are defenses to contract formation. So that's my mnemonic. It's pro-evidence, ambiguity. I don't have it on top of my head, but this is for the defenses for actual contract remedies. Okay, so you have to know those. Those might have some kind of effect on your essay if you're doing specific performance. And one thing I'm going to add on here is obviously a specific performance is an injunction. For the court to apply an injunction, let me see if I can go. Okay, so I'm going to put that here, down here. Injunction. That's what the person will be awarded an injunction to stop the other person from selling the property, or however that's going to work. So that's important too. I'll leave that there. I gotta save that part. So basically, courts usually prefer specific performance because land is unique. Chocolate cheesecake is my favorite dessert, is my mnemonic. Valid contract, conditions satisfied, inadequate legal remedy, mutuality, feasibility, and there must be no defenses, okay? And the court will award the injunction. So let's go ahead and go back to our top here. We're going to start, oh, actually I have the approach down here. Approach, so the rule, we talked about the rule. Merger doctrine, contract law, statute of frauds. How do you get out of statute of frauds? There's some exceptions. It's PIP, part performance, substantial improvements, and partial payment of, or all purchase payment made. Marketable title. You know what, did I go over marketable title? I didn't see it on there. Equitable conversion and remedy. I don't think I did marketable title. Let's go back and see here. So we didn't do marketable title. We do have to throw that one in here. So let's throw marketable title in here. Okay, so marketable title. I'll do that with you guys right now. Marketable title. Let's get all the elements for this one. Now, every contract has an implied promise in every land sales contract that the seller promises to convey marketable title. And that's implied in every land sales contract, and they will ask you that in MBE, so make sure you know that, okay? And this has to be done at the time of closing. So they do have time to fix things, and you'll see on some of the MBEs, they don't close, and they still have time before the closing date, and they're asking you, are they allowed to do so? And they are, okay? Marketable title is title that is free from reasonable doubt of the buyer going to court to take off like an encumbrance, like an easement or a lien on the property. So that's what it is. So free from reasonable doubt. Okay, from reasonable doubt that the land has any, let's see, encumbrances. Record chain of title. I'll go over these in a second. Or easements. We know what those are. Or use restrictions like covenants. Okay, so basically it has to be free from reasonable doubt that the land has any encumbrances, and encumbrances such as an outstanding mortgage or a lien, but the seller has until escrow closes to pay it off. So that's the tricky part here. They do have until escrow closes to pay it off. The record chain of title indicating the seller does not have a full interest in the property to convey. Is it his? Can he convey it? Okay. An easement, if it has an easement, it reduces the full enjoyment of the premises. That's not marketable title. Use restrictions, are there any real covenants? And if there is, that's not marketable title. So we have to go through all the different components of marketable title to see if any of the facts bring these up. And if any of these do, and he does not, he goes all the way up until closing, doesn't fix them, then that can be reason for the buyer to back out. Okay, so let's go through them one more time. I kind of did it backwards now. Our approach again. rule, merger doctrine, contract law, marketable title. Got to talk about that. Those are in MBEs too. Equitable conversion. It converts automatically at the time of contract signing to the buyer. Risks of loss goes to the buyer also if there's any damaged property pieces. And then the remedy is usually an injunction, specific performance of damages. They prefer specific performance because a contract is unique. Okay, so that's all of it. And that's my land sales contract. Quick, write it up quick, maybe a paragraph or two, and then move on to your next issue. Good luck on the bar exam, and thank you for listening.